USCIS and ICE agent website, U-Visa, T-Visa and VAWA updates. Welcome to this official immigration update from U.S. Immigration and Customs Enforcement, ICE. Today, we address important questions regarding U-Visa, T-Visa, and VAWA policies in 2025. Question: what has changed? ICE previously required a prima facie determination from USCIS before taking action on U-Visa cases. However, as U-Visa applications increased, this process became burdensome. To address this, ICE issued Directive 11,005.3, which allows ICE officers to use prosecutorial discretion when handling crime victims or witnesses, ensuring better access to justice and victim-based immigration benefits. Question: will the changes negatively affect crime victims? No. ICE will not take enforcement actions against applicants for U-Visa, T-Visa, or VAWA protections until USCIS makes a final determination. This includes pending T-Visa applications and special immigrant juvenile cases, U-Visa petitioners awaiting a bona fide decision or placed on a waiting list, VAWA applicants who receive a negative prima facie determination. Question: will ICE remove crime victims assisting law enforcement? No. ICE recognizes the importance of victim witnesses in law enforcement cases and will refrain from taking civil immigration actions against those with pending victim-based immigration benefits unless exceptional circumstances apply. Question: can U-Visa petitioners still be deported? Yes. If a U-Visa has not been adjudicated, petitioners may still face removal depending on their individual case. However, they have the same legal rights as any other person in removal proceedings. Question: why has the number of U-Visa applications increased? More attorneys and law enforcement agencies now recognize the U-Visa as a tool for protecting crime victims, leading to an increase in applications. Question: what happens if a U-Visa petitioner is deported before approval? If a person is removed from the U.S. and later granted a U-Visa, ICE defers to USCIS and the U.S. Department of State for further action. Question: how many U-Visas are approved annually? USCIS approves 10,000 principal U-Visa applications per year, as required by law. Question: will ICE notify law enforcement before removing a U-Visa petitioner? Yes. If a stay of removal is denied, ICE will notify the investigating agency before proceeding with deportation. Question: does a granted stay of removal extend to family members? Yes. Qualifying family members included in a U-Visa petition may also receive protection under ICE Directive 11,005.3. Question: why doesn't ICE comment on specific U-Visa cases? Federal law prohibits ICE from disclosing details about U-Visa, T-Visa, or VAWA applicants, including case status or personal information. These privacy protections extend to family members as well. Closing statement: if you or someone you know is applying for a U-Visa, T-Visa, or VAWA protection, stay informed about your legal rights. Visit the official U.S. Citizenship and Immigration S.
Immigration law can be very complicated. Navigating through the myriad of rules, regulations, and paperwork can be overwhelming for anyone, especially for those who are new to the country and unfamiliar with the legal system. Understanding the different types of visas available is crucial for immigrants seeking to live and work in the United States legally. There are many different visas and rules. Each visa serves a specific purpose and has its own set of eligibility criteria, application processes, and benefits. Knowing which visa to apply for can make a significant difference in an immigrant's journey. This essay will talk about 3 important visas: U-Visa, T-Visa, and VAWA. These visas are designed to protect and assist immigrants who have faced severe hardships and need legal status to rebuild their lives. These visas help immigrants who have been victims of crime or abuse. They provide a lifeline to those who have suffered and offer a chance for a new beginning in a safe environment. The U-Visa is for people who were victims of certain crimes in the United States. This visa is specifically for those who have endured significant physical or mental abuse as a result of criminal activity. To get a U-Visa, you need to help law enforcement with the investigation or prosecution of the crime. This cooperation is essential as it helps authorities bring perpetrators to justice and ensures the safety of the community. The T-Visa is for victims of human trafficking. Human trafficking is a grave violation of human rights, where individuals are exploited through force, fraud, or coercion. Human trafficking is a serious crime where people are forced to work or engage in commercial sex acts. Victims often endure inhumane conditions and are deprived of their freedom and dignity. VAWA helps immigrants who are victims of domestic violence. The Violence Against Women Act, VAWA, provides protection and support to those who have suffered abuse at the hands of a spouse, partner, or family member. Domestic violence is abuse by a spouse, partner, or family member. It can take many forms, including physical, emotional, and psychological abuse, and it often leaves lasting scars on the victims. These visas are important because they offer protection to vulnerable immigrants. They provide a legal pathway for those who have been wronged to seek justice and rebuild their lives. They allow immigrants to stay in the United States legally. This legal status is crucial for accessing essential services, finding employment, and integrating into the community. These visas also give immigrants a work permit so they can support themselves. Being able to work legally provides financial stability and independence, which are key to starting a new life. In some cases, these visas can even lead to a green card, which allows someone to live and work in the United States permanently. This permanent residency is a significant step towards achieving the American dream. These visas recognize that immigrants who are victims of crime or abuse need help. They acknowledge the unique challenges faced by these individuals and provide the necessary support to overcome them. They give immigrants a chance to rebuild their lives in safety. With the protection and opportunities these visas offer, immigrants can focus on healing and building a brighter future. They offer a path to a better future for immigrants and their families. By providing legal status, work permits, and a potential pathway to permanent residency, these visas empower immigrants to contribute to their communities and achieve their goals. In 2025, ICE, Immigration and Customs Enforcement, has introduced new policies that significantly affect immigrants living in the United States. These policies are designed to address various aspects of immigration enforcement, and they have far-reaching implications for many individuals and families. These policies can be quite confusing, especially for those who are not familiar with the legal jargon and the intricacies of immigration law. Therefore, it's crucial to understand them thoroughly to navigate the system effectively and ensure that you or your loved ones are protected. In this section, we will delve into the specifics of who is safe from deportation under these new policies. Understanding these protections can provide peace of mind and help you take the necessary steps to secure your status. One of the key protections is for individuals who have a pending T-visa application. The T-visa is specifically for victims of human trafficking who have assisted law enforcement in the investigation or prosecution of human trafficking cases. If you have a pending T-visa application, you are safe from deportation. This means that while your T-visa application is being processed, ICE cannot deport you. This protection is crucial as it allows victims of human trafficking to remain in the country and continue to assist law enforcement without the fear of being deported. Another group that is protected under these new policies is special immigrant juveniles. These are children who have been abused, neglected, or abandoned by one or both parents and have been declared dependent on a juvenile court. Special immigrant juveniles are granted protection because of their vulnerable status. They are often placed in foster care or with legal guardians, and the protection ensures that they are not deported while their cases are being processed. If you have a pending U-visa application, you are generally safe from deportation as well. The U-visa is for victims of certain crimes who have suffered substantial mental or physical abuse and are helpful to law enforcement or government officials in the investigation or prosecution of criminal activity. However, there are some exceptions to this protection. If the United States Citizenship and Immigration Services (USCIS) makes a negative bona fide determination, you may not be safe from deportation. This determination means that USCIS does not believe you are a victim of a qualifying crime or that you have not met the necessary criteria for the U-visa. A negative bona fide determination can be a significant setback, but it is important to seek legal advice and understand your options if this happens. There may be other forms of relief available, and an experienced immigration lawyer can help you navigate this complex situation. If you have a pending VAWA, Violence Against Women Act petition, you are also safe from deportation until USCIS makes a decision on your case. The VAWA petition is for victims of domestic violence, and it allows them to seek protection and legal status independently of their abuser. This protection is vital as it empowers victims of domestic violence to come forward and seek help without the fear of deportation. It provides them with the time and security needed to build a new life free from abuse. While your VAWA petition is being reviewed, ICE cannot deport you. This gives you the opportunity to gather the necessary evidence and present your case effectively. Understanding these protections and knowing your rights can make a significant difference in your immigration journey. It is always advisable to seek legal assistance to navigate these complex processes and ensure that you are taking the right steps to secure your status and protect yourself and your family. While many immigrants are safe from deportation under the new ICE policies, it's important to understand that not everyone is completely out of danger. The policies have provided a sense of relief to many, but there are still specific groups of individuals who remain vulnerable to deportation. Some immigrants are still at risk, and it's crucial to identify if you fall into one of these categories. Knowing your status and understanding the risks involved can help you take the necessary steps to protect yourself and your loved ones. It's crucial to know if you fall into this category so you can take appropriate steps to protect yourself. Consulting with a knowledgeable immigration attorney can provide you with the guidance you need to navigate these complex situations. One group at risk is U visa applicants whose petitions have been denied. The U visa is designed for victims of certain crimes who have suffered mental or physical abuse and are willing to assist law enforcement in the investigation or prosecution of the criminal activity. However, if your petition is denied, you lose the protection from deportation that the U visa provides. If USCIS denies your U visa petition, you will no longer be protected from deportation. This can be a devastating blow, especially for those who have already endured significant trauma. It's essential to understand the reasons for the denial and to seek legal advice on how to proceed. This is why it is important to have a strong case and to work with an experienced immigration attorney. An attorney can help you gather the necessary evidence, prepare your application, and represent you throughout the process. Another group at risk is T visa applicants who have received a final negative decision. The T visa is for victims of human trafficking who are willing to assist in the investigation or prosecution of trafficking cases. A final negative decision means that your application has been denied and you have exhausted all appeals. In this situation, it's crucial to contact an immigration attorney immediately to explore other legal options. There may be other forms of relief available to you, and an attorney can help you understand your rights and options. Finally, VAWA applicants who fail the prima facie test are also at risk. The Violence Against Women Act, VAWA, allows certain spouses, children, and parents of U.S. citizens and lawful permanent residents to file for immigration relief without the abuser's knowledge. The prima facie test determines whether you have presented enough evidence to establish that you are a victim of domestic violence. If you fail this test, your VAWA petition will be denied, and you could face deportation. This can be a frightening and overwhelming experience, but it's important to remember that you are not alone. There are resources and support available to help you through this difficult time. In conclusion, while many immigrants are safe from deportation under the new ICE policies, there are still specific groups who remain at risk. U visa applicants with denied petitions, T visa applicants with final negative decisions, and VAWA applicants who failed the prima facie test are all vulnerable to deportation. It's crucial to understand your status and to seek legal advice if you find yourself in one of these categories. An experienced immigration attorney can provide you with the guidance and support you need to navigate these complex situations and to explore other legal options that may be available to you. Remember, knowledge is power. By understanding the risks and taking proactive steps, you can protect yourself and your loved ones from the threat of deportation. Stay informed, seek legal advice, and take action to safeguard your future. The journey may be challenging, but with the right support and resources, you can navigate these difficult times and work towards a more secure and stable future. The immigration system can be complex and daunting, but you don't have to face it alone. Reach out to trusted legal professionals and support organizations to help you through the process. Together, we can work towards a fairer and more just system that protects the rights and dignity of all individuals regardless of their immigration status. If you or someone you know is at risk, don't wait. Take action today to protect your future and ensure your safety. The path may be difficult, but with determination and the right support, you can overcome these challenges and build a better future for yourself and your family. Stay strong, stay informed, and seek the help you need to navigate the complexities of the immigration system. Your future is worth fighting for. Section 4. What happens when USCIS denies a petition? Having your USCIS petition denied can be a scary and confusing experience. It's essential to understand the potential consequences and know what steps you can take to protect your rights. When USCIS denies your petition, you will receive a Notice to Appear, or NTA. This document informs you that you must appear before an immigration judge, who will decide whether you should be deported. Receiving an NTA doesn't mean you will be deported, but it does mean you must take immediate action. If you already have a deportation order against you, receiving an NTA could lead to detention by ICE. detention means you will be held in an immigration detention center while your case is pending. These centers are often overcrowded and lack adequate medical care. Additionally, USCIS can revoke your work authorization if your petition is denied. This means you will no longer be legally allowed to work in the United States, making it difficult to support yourself and your family. Section 5. Important steps after your petition is denied. If your USCIS petition has been denied, don't panic. There are still steps you can take to fight for your right to stay in the United States. First and foremost, contact an experienced immigration attorney immediately. An attorney can review your case, explain your options, and help you navigate the complex legal system. They can also represent you in court and advocate for your rights. If you believe USCIS made a mistake in denying your petition, you have the right to appeal the decision. An appeal is a request to have your case reviewed again by a different decision-maker. Your attorney can help you file an appeal and present a strong case for why your petition should be approved. During removal proceedings, you can request prosecutorial discretion. This means asking ICE to consider your specific circumstances and choose not to pursue your deportation. While there's no guarantee ICE will grant prosecutorial discretion, it can be a valuable option in some cases.